Ladies and gentlemen, good evening. It's a pleasure to be speaking to you this evening, my time, here in Hong Kong, and to be the moderator of this panel. This panel is entitled Cross-Border Enforcements, Defaults and Asset Tracing. That, of course, is a huge topic, and we cannot possibly hope to cover everything, or even just a little part, but maybe we'll have an opportunity to look at one or two areas. First, let me introduce myself. My name is Ian D. Witt. I'm a solicitor here in Hong Kong, in the Hong Kong firm of Tanner de Witt, which is one of the larger independent firms. I originally hail from the United Kingdom, but many years ago I was drawn to Hong Kong for the same reasons that brought many of us here. The clean air, the wide open spaces, the blue water lakes, as you can see behind me, and the snow-capped mountains. Now, turning to the panelists, I'm pleased to introduce to you Vijayendra Pratap Singh. Now, he's a partner and head of AZB and Partners based in Delhi. Now, he's a man of many talents, a man who's seen it all, albeit understood very little of it. From reading his CV, he's a man that's done so many wonderful things in such a brief time. It's really hard to exaggerate his accomplishments. But that said, I will try to do my best. He has been involved in a number of international commercial and domestic arbitrations, a lot. He's been heavily involved in the electricity sector. And of course, like all thoroughly decent people, he's a solid commercial litigator like myself. He has many accolades, and he's been involved in some of the larger insolvency and restructuring projects of recent times. Also on the panel, I'd like to introduce a man with a lot of charm, talent, and wit. But unfortunately, he couldn't be here this evening. So instead, we have Arush, Khanna, who is a partner of Numen in Delhi. And he comes from a family of lawyers, fifth generation, in fact, and a co-founder of his law practice, specializing in commercial disputes and arbitration, representing several Fortune 100 companies. And he is an ALB rising star. And all I can say, from one waning star to one rising star, I'd like to congratulate him. And he looks so much younger than me, which is strange because I'm sure we are, in fact, the same age. I tell you, I used to have black hair and weigh 13 stones before I came to Hong Kong, so I am living proof of what living in this town can do to a man. My third guest is Michael Redman of Burford, a man who surely needs no introduction. So let's move on. No, only joking. But Michael's hobbies include scuba diving and embroidery, and he is a fan of Roger Moore. And indeed, who isn't? And if Michael had his time again, he tells me he would be a gigolo. And indeed, who wouldn't? I've managed to make a career out of it. He's a managing director and co-leads Burford's corporate intelligent asset tracing and enforcement business. He's been in the business a long time, and frankly speaking, he knows his stuff. And he also knows the Arush. In fact, I could sit here for an hour or so and continue to talk about his accomplishments, but only if I talked very, very slowly. Now, let's turn to the topic in hand. Now, here in Hong Kong, there have been many developments over the years with regard to cross-border issues. As regards judgments, we have systems, we have reciprocity. You can bring judgments here from some jurisdictions. As regards tracing of assets, unfortunately, Hong Kong has become a banking center for various fraudsters and scammers. So the courts are very used to and very acquainted with taking speedy actions, identifying foreign proceedings, recognizing them, and obtaining and granting injunctions, disclosure orders, marriage pharmacal, bankers' trust orders. And indeed, we can get these orders as quickly as a day in Hong Kong. But mostly we see cross-border enforcement in the field of insolvency, where liquidators in foreign jurisdictions come over to Hong Kong and have their position and powers recognized. And this is now very common. I venture to say not quite procedural, but not too far off. And there have been and continue to be a lot of developments here. For example, as recently as last month when the Hong Kong court recognized HNA's mainland reorganization here in Hong Kong. But we're not here to talk about Hong Kong particularly. We're going to talk about India. And first of all, I wanted to ask Vijayendra, I wanted to ask what your experience has been with regard to cross-border enforcement and recognition.
So there is what I call the honor of gentleman. And that's the adage that works with respect to cross-border enforcement in India for insolvency. As you're aware, we do not have a proper law or a regime which actually specifies with certainty the entire process. However, we've managed to find our own jugaad or what we would call the Indian way of finding a solution to the absence of legal certainty or a legal framework. That said, we've done this not just recently. We did this and have been doing this since 92, 93. I think that's the first one that I know of. And I'm not even going back to when we had the British here. Pretty much like Ian would not go back to the time when he had the British there as well. And the reason is that with the Commonwealth, we used to have the King or Queen's order should be respected across all realms of the Commonwealth. And that committee of understanding and enforcement allowed for a number of orders from various jurisdictions to be enforced in India. But that gave way to independent India. And in independent India, the first major insolvency that I've seen, which was a cross-border insolvency that was facilitated, was actually the Bank of Credit and Commerce International, where the Cayman liquidator or administrator actually came to India to look at some of the deposits that lay with Indian banks here. And lo and behold, who did act as the liquidator in that matter? It was the Central Bank of India, the Reserve Bank. So the Reserve Bank, under an informal or an ad hoc order passed by the Bombay High Court, helped facilitate the outreach with respect to India-seated assets by a foreign administrator in a proceeding with respect to an international bank which was facing a meltdown across the world and was therefore being wound up in its home jurisdiction. And we did this without the benefit of any legal regime. And if we had tried to do it with our legal regime, I'm sure that we would still be here and the money would still be accruing some interest in an Indian court, which may not have been a bad set of years because the last 20 of them, for the last 20, 22 years, India has been a high interest regime for about 17 of them. That said, it would not have been the answer to the asset which needed to be resolved in the insolvency. However, things have moved on since then. We have had courts in India more regularly recognize international administrators or insolvency professionals coming into India and giving them at least their time in court or at least a say in court. Having been involved in a matter which was the interplay of arbitration and insolvency, and that fairy tale we'll leave for some time later, I have first-hand experience about how an arbitrator will deal with it and how a court will deal with it. An arbitrator will say that the foreign moratorium or standstill order is not going to be recognized. And that comes with the nature of the beast that we are in India, where we have a limited number of players of orders which we can actually recognize. Therefore, the moratorium order will not be one unless there is a framework around it. The second is the fact that it's not a final order, it's not a judgment on merits, therefore there is no reason to recognize it under Indian law. And I think that's the standard that most arbitrators do take. On the other hand, a court recognizes the order of appointment as a matter of stature and gives you the ability to address and answer the court with respect to the named party who has gone into insolvency. But the last and the most positive green shoot that I have seen is actually been the JET insolvency and the cooperation agreement that came about, or the cooperation protocol as it was called. And it came about despite the lawyers. And that's what I would say. This is where insolvency is different from litigation. Insolvency is the happening of the possible. It is I am possible as opposed to impossible, because you get guys who want to get their money or see the color of money, sit down and find out how are they going to reach out and find the best bang for the buck. And the protocol summed it up. It talked about two sets of people saying both of us are going to be given certain rights. We don't want to be anointed king, but I will have a certain amount of deference for you. Please come in, participate in my proceeding, and in lieu of you participating in my proceeding and getting, in fact, a preferential payout under the plan, you are able to bring in the overflow of the aircraft that were there in the foreign jurisdiction back to the Indian jurisdiction to make good claims of Indian creditors, which otherwise may not have happened had each of the lawyers had their day in court. And I may be castigating the lawyers a lot more than I should, But I believe that the true credit for this framework, of course, goes to the lawyers, but was actually paid for and thought of by the bankers and the investment bankers who got involved. Because you had an asset which would waste away, you had bills that needed to be paid today, and you had the ability to only allow for comity to be the consistent soul of insolvency. In the absence of the same, I don't see us having found a solution there. We do hope that we will not just see this as the one-off situation. And while the protocol gives us an ad hoc answer to deal with issues, it still is something that needs to be codified because you want the 3 C's to play out for you: consistency, comity, and certainty. Anyone who's coming into an international insolvency wants to know how long, how much of the asset can it reach out to, and what are the rules of the game before they come in. It needs to understand, and each jurisdiction needs to understand that in ceding what is the main proceeding, you are not giving up legal sovereignty. And that's what I would call is the core of legal jingoism. And if you can get past that, you will find solutions. And at times, it is easier to find that solution by the people who are interested in the solution than at times the solution provider. Because one does need to keep in mind that at the end of the day, the game that we are playing is resolution. It's the name of the game, it's the object of the game, and it is the only game. We do not want to make precedents. We want to pursue profit. And if that is the understanding in India, you will find that these 3 examples, all 3 of them at different points of time, in different areas, go ahead and give you a certain degree of comfort that if you have your heart in the right place and the mind on the correct objective, you will find a solution. And I think that is the story of the Indian cross-border insolvency outreach. It gets a lot more trickier when we have to try and trace these assets abroad. And that's where I believe the Indian insolvency regime has to be tested, because the ad hocism here is not reciprocated in various jurisdictions where you have assets. So you've had dwellers who've run away. Now, finding a diamond is always difficult. Finding an elusive diamond is even more difficult. And I'm sure we're going to have our friend come across and tell us exactly how he's going to help us do that. And it is these tricky situations which make for what you call the development of law. But if there is a basic framework of law, it will help us go in the right direction. And to that effect, the ILC report, which talks about cross-border insolvency, actually starts at a very good place. It takes the model law as the basis. It makes certain changes on that basis and goes ahead and provides a good framework. But as is the case with all IBC-related instruments, I believe it's not going to be a work of art. It'll be a work in progress. And the way this law has developed, it has always been a work in progress. And I'm glad that it's work in progress because it provides solutions to problems that comes its way. And I'm hoping that the cross-border element will also go the same way. Otherwise, as Ogder says, that insolvency is a state of affairs where a person unable to pay his debt sees his lawyer and his accountant split his estate. I'll leave my piece for later. Thanks, Ian.
Well, thanks for that. That's a tremendously optimistic outlook, and good on you for that. I share that. From another jurisdiction that here in Hong Kong that possibly doesn't have its legislation quite as it might have, but nevertheless is able to adapt and has adapted very well using the common law in particular. I congratulate you there. The protocol sounds very exciting. I take what you say about diamonds and tricky to find. That's what my wife always says. And one of these days, I really got to buy her a ring. Castigating lawyers, yeah, for sure. But I think we're used to that, aren't we? Really. But I also endorse your comment about insolvency lawyers, or our practice generally, and the happening of the possible. Again, I think that's a very very optimistic and wise words. Thanks thanks for adding that. I enjoyed that. Michael, can I turn to you just for a moment? Because litigation funding is very certainly here it's very sexy and it's a big thing, as it is in Singapore now, and it's big business certainly in the United Kingdom and Australia. But I wanted to turn to you on whether or not you would like to make a few introductory comments about finance, third-party funding in the context of recoveries and MPLs.
Yeah, and thanks, Ian. We always find ourselves in this business as kind of like the odd one out on a panel. We're not practicing lawyers in this context, obviously. And so it kind of bears some explanation in terms of why I'm here, if I can put it like that. We are providers of capital, but we're providers of capital in a very specific and unusual circumstance, which is things like insolvency and things like debt, whether is either through litigation, negotiation, whatever else, money to be recovered around the world. And as someone said in a previous panel, there is plenty of capital out there in the market at the moment, looking for a home, looking ideally for a profitable home. But I suppose we service the end of the market where there are few or no assets in the estate itself, or with the creditor that they can self-finance the process, and for whatever reason they want to share the risk. And that risk is not one that can be easily judged based on a balance sheet analysis or on a spreadsheet, but involves some technical legal analysis, and that's where we come in. So we are one of two handfuls of professional litigation finance firms that operate in this space. And it probably bears some explanation in terms of definition, and it does change from jurisdiction to jurisdiction based on level of kind of engagement with the industry. But people typically talk about third-party funding, TPL. I'll be talking about litigation finance, which is kind of it encompasses TPL, but it also is broader than that. And what it is using capital as part of a solution, kind of writ large, as long as there's a legal context. So the business has matured to be greater than the old one-off case that we come in, finance, and walk away from. And so it's kind of in this context, you see us getting involved increasingly in things like non-performing loan portfolios, insolvent estates, and really just with corporates who, for whatever reason, want to share some risk and want to work and partner with a firm like ours to generate external finance so that they can manage their own balance sheets and income statements and be creative about how they use capital at any one time. So it's a work in progress, and there's an opportunity in India that we'll come back to, and I'll go into more depth about that. But I think that was just a brief introduction in terms of why I'm here and what I'm going to be talking about. So I'll pass that back to you.
No, that's useful. I mean, it is a big business now. Let's be honest, and I think it's going to get larger. As to why you're here, Michael, you're a smashing bloke. That's why you're here, and that's a good enough reason for me, for sure. Plus, you guys have the money, which is always good as well. But turning to Arush, do you have some views? I'm particularly interested in your experience as well, either your personal experience or what you've seen generally on the adequacy or inadequacy of any Indian legislation on this subject.
Thank you, Ian. I trust I'm audible. At the outset, I'd like to express my heartfelt gratitude. It is my privilege to be a part of this most luminous panel and share the virtual dais with senior colleagues and eminent friends. Now, corporate and insolvency and bankruptcy is an undesirable yet important component of any country's economic landscape. Whilst the roots of insolvency and bankruptcy can be traced from as far as back as when trade and commerce on credit and borrowed capital actually started, India has only seen its legislation as recently as 5 years back. The Insolvency and Bankruptcy Code was promulgated 5 years back with a broad objective to efficiently manage insolvent entities as going concerns and to ensure maximization of asset value for all creditors. So to start, I'd like to say that insolvency jurisprudence in India is a very nascent one and is a frequently evolving one through a plethora of amendments as well as judicial precedents. As VP sir was saying, we're glad that it's an evolving one and it's work in progress, it's not a work of art. Coming to the issue of cross-border insolvency, theoretically speaking, the code does provide for two sections, namely 234 and 235 of the code, that were notified much after the main act was notified, and they provide for some provisions pertaining to cross-border insolvency. However, to the best of my recollection, those provisions have been underutilized. And how? Section 234 says that a central government can enter into reciprocal arrangements with governments of any other nation to enforce the provisions of each other's insolvency laws. Now, to the best of my recollection, this provision hasn't been utilized at all. As of end of 2020, India doesn't have a single reciprocal arrangement, any bilateral agreement with any country. Section 235 says that in relation to the countries with which India has a reciprocal arrangement, a resolution professional may make an application seeking a letter of request that is to go from India to the country in which the assets of the corporate entity is located. Now, as you would aware, as the Americans call it, a letter of rogatory, that goes through the Hague Protocol, and it's a time-consuming process. It goes to official channels. And therefore, the current framework as it exists is not time efficient, and it does not ensure the objective of the IBC, i.e. maximization of value of asset in a time-bound manner is achieved. The Indian law provides for a period of 330 days, as directory, of course, not mandatory, to conclude a corporate insolvency resolution process. And if we are to invoke the provisions for cross-border insolvency, I don't think we can meet within the timeline. So there was this UN model law, which was promulgated in 1997. And it's been, as we speak, it's been ratified by 44 countries. India, regrettably, despite the ILC report calling for it to be a part of it and to ratify or to adopt it, India has not yet adopted it. I think it's high time, just like we did with our arbitration regime. The NYC dispenses with our requirement to enter into any bilateral agreement. And if India, of course, it's ratified the NYC, and that's why it can enforce foreign awards without having any issue of bilateral or reciprocal arrangement with that respective country. So I think the call for adopting the UN model laws in whatever way couldn't have been louder, because if we can do that for arbitration, for our arbitration law, and I think we've seen the light of the day in that. I think India's pursuit of becoming a hub for international commercial and investment arbitration has really been sort of aided by our enforcement of foreign awards regime. I think in the last 6 years, only 2 judgments have been passed by the Apex Court that have resisted enforcement of foreign awards. Only 2. And I think that speaks a lot. So I think with that kind of a harmonious and seamless approach is even required in our insolvency regime. And I think what VP sir was saying, I quite agree with him. Perhaps we need to broaden the scope of enforcing foreign orders in India. Currently, the CPC, section 13 and 44 capital A, provide for enforcement of foreign orders, but those are final orders. Why can't we have those applying to moratorium orders passed by any foreign country? Why can't we expand the scope of the CPC so as to include orders passed by an insolvency court? I think that can also aid the process. One of the first, even though, just like to speak a little about the famous Jet Airways case, formerly, of course, India's largest private airline. Even though India has not adopted the UN model law, the courts have interpreted the model law and have applied it in the Jet Airways case. Now, in the Jet Airways case, our appellate authority, the NCLAT, as it's popularly known, actually set aside the order of the NCLT and onboarded the administrator the foreign administrator to be a part of the COC. And like VP sir was saying, he got a preferential treatment that even though he did not have voting rights. And what did that do? We adopted the cross-border insolvency protocol, quote unquote, which was adapted from the UN model law. The resolution was arrived at, and the overflow, as sir was saying, the overflow from the sale or the utilization of the two jet planes at Schiphol airport were used to satisfy the claims of the Indian creditors. So today, I think in any provision that calls for reciprocity and a bilateral agreement is subject to its whims and vagaries. You cannot have one arrangement with the UK that is going to be identical to that with, let's say, another country, let's say an African country for that matter. There will be vagaries, and those will lead to anomalies, thereby disrupting the process. I think the call for adopting the model law couldn't have been louder. And I think with the evolving jurisprudence that India's insolvency is, I think sooner rather than later, we will have a robust framework for, enforcing, or rather, for better asset tracing and enforcing insolvency so as to ensure maximization of credit value. Because as we know, data is very porous. Globalization is the new normal. I think we need a universal regime sooner than later. With that, I'll hand it back to Ian.
Well, that's an interesting. You made some interesting comments there. I'm surprised there have been no agreements at all on reciprocity. But I suppose these things do take time, and I speak from Hong Kong perspective as well. I wasn't going to ask this, but Vijayendra, what's your take on that? I mean, obviously you're part of the same system there, and Yin's trial model law, of course, is terrific. We don't have it in Hong Kong either. But what's your take on that? I mean, is it something that's going to be adopted at any time, or can be, or is there the appetite to do so?
So the good part is that there is a significant amount of appetite for changing and evolving this law. And I believe that's shown with the number of amendments that we've had in the law, the staggered nature of its incorporation or coming into force, and the ability to course correct. So you've seen that the law finds that wherever there is a gap, it tries to make good that gap. And where the law has not been able to do so in the interim period, court orders or the orders from the authority, like Arush was mentioning, from the appellate authority, blessing or baptizing a protocol, are the way forward. This can only happen in a system that believes in the 5 things that make up the fist of the IBC, which are A, time-bound resolution, B, maximization of realization, C, the issue with respect to unlocking credit, D, a priority where the government has taken a backseat, and E, international cooperation. Because it does recognize that India cannot be unconnected with the world, and despite being a capital control country, we do invite capital from outside, and including debt capital. And that is to be honored, and it's going to be feeling safer if we are able to provide this. The government is likely to introduce the change in the law shortly, is what my guess is. How quickly is another question. But I do believe that there is not only intent, but there is action to ensure that there is access, there is relief, and there is comity, or what I call the ARC principle, which will go on to make what is the fulcrum of our cross-border insolvency law.
Yeah, no, that's good, very succinct, and as ever, very optimistic. And I as a glass half full person myself, I'm pleased to hear that. Our legislation has been on the books since I first came to Hong Kong in 25 years, and it still hasn't been passed. But let's not go there right now. But nevertheless, like as you were saying, the courts adapt and the professions adapt, and it has adapted. That's the beauty, I suppose, of the common law. But anyway, just take a little side here, because going back to money, it's very important, litigation financing. And which is an increasingly important area. Certainly, we've seen it. In Hong Kong, we have issues about litigation funding contingency. We still have the old rules against champerty maintenance here, except we have some exceptions in the insolvency, the bankruptcy as it was, the bankruptcy exception, and also in terms of, well, I suppose, general area, but justice, but which hasn't really been sorted out. But Michael, I wanted to know about litigation financing and whether it has a role to play there in defaults and recoveries. And I wanted to know whether it was legal in the Indian context. And if it was, how does the structure work? How does you put it together? And indeed, I suppose, if you can, what are the pitfalls? I have a fair idea what they are here in Hong Kong, because we have several arrangements where we use litigation funding in the bankruptcy insolvency context. But I'd be keen to know what's going to be happening, what is happening in India and what's going to happen.
Yeah. Litigation finance, we talk about separately to finance, which is in some ways peculiar because our money's as green as anyone else's. So, so why is it different? Litigation finance is non-recourse finance. So we don't take security. We don't, put a mortgage on anyone's house or ask for backup in the case of a loss of one of our investments. We get paid if and when and only if a recovery is made from the piece of litigation or the recovery efforts that we are financing. If that falls down, the loss sits with us and only with us, which partly explains why it's unusual, because it's high risk. Losses do happen, of course, they do happen, and it does explain why the returns that we expect are slightly different. And so that's why we talk about litigation finance as being different to any other kind of finance from distressed funds or high street banks or whatever else. As to whether it's legal in India, as you say, in the question of legality comes back to pretty much medieval feudal England concepts of champerty maintenance and barity, which have just stayed on the books in some places and off the books in others. And what that boils down to is intermeddling in other people's pieces of litigation and abuse of the court. I think that's no longer on the books in England, and it's there's a process for getting off the books elsewhere. And as you say, there are exceptions around the world for access to justice, things like insolvency, and things like arbitration in some jurisdictions. In India, I understand that it is permitted, and that's putting it aside from things like contingency fees for law firms, which is a whole separate issue. And there was some very positive comments a few years back. I suppose it was it's before the pandemic, but it's probably going back to 17, 18, I think, from the Indian Supreme Court saying that non-lawyers like us can have a stake in the outcome of a piece of litigation. And that's, from our point of view, all for the positive and right and how it should be, as long as the conduct of the agreement is on the right side of champerty maintenance, which it is, because we are a self-regulated industry. It's in our interest to maintain that conduct as being appropriate in this situation. So that's all for the good. There are various structures that we put in place or can put in place to finance recoveries, insolvencies, and pieces of litigation. And they range from the traditional third-party finance model of partnering with firms, with claimants, providing an amount of capital for the payment of court fees, lawyers, experts along the way, in whatever jurisdiction, and then obviously getting that back if and only if that works out, through to things like assignment and what some people call monetization, which is essentially providing some upfront capital to the claimant for the right of participation in the outcome. And that's typically where we do see some interest from the Indian market, because undoubtedly there is a lot of interest in this as a potential financial solution, because there's a lot of judgments, there's a lot of debts swirling around the market that require some financing to get off the ground. And it works out in the favor of claimants, particularly corporate claimants in a lot of these cases, because it allows them to manage their balance sheet in these kind of things. One, they're removing the ongoing legal spend in pursuing the debts. If there is some upfront consideration paid, in some cases there is, then they book it as income, and they can choose when they book the income from the resolution. So they're taking off the cost, but deferring the income on their books. So that's typically, our approach to the market in whatever shape or form that it is. There are obviously pitfalls, and a lot of the pitfalls that we face are structural, and they're around, frankly, us getting our capital out of the Indian market, which there are restrictions on that, and that's what we do face. So where we have seen some success is with Indian counterparties pursuing recoveries outside of India, which means that we have a route to recover, our entitlement. When we do make an entitlement, funds flow back to India, the contract's in place, but it's kept outside of the Indian jurisdiction, so that we don't face anything like that. In terms of other pitfalls, obviously there are many. I think a lot of it comes down to novelty, and we've sorted out those kind of issues in other jurisdictions simply by exposure, people becoming more aware of what litigation finance is, what it isn't, and how these kind of agreements look. And frankly, we see great prospect in the Indian market, but it's going to take some time to get there as people become more acquainted with this, and kind of have a greater appreciation for how it can be used in this context. So that's fairly rambling explanation of kind of what it is and how it's used. But the archetypal example is Indian corporate who has an unenforced arbitration award against a foreign respondent. We come in, we pick up the tab for the process along the way, and return capital if and only if we make a recovery from the process that we're financing.
Sounds perfect. You pick up the tab is all I heard there, and that sounds terrific. Arush, I was just curious whether or not, I wasn't going to ask this either, but being as Michael was talking about it, have you had any experience or are you looking forward to receiving, or is financing an issue with regard to, you see, cross-border issues tend to be tend to be more expensive because we have to involve so many more aspects in different jurisdictions, particularly if you're a Hong Kong only firm as we are. So, but anyway, so any experience of the litigation financing in this context?
Well, Ian, the concept of litigation finance is still very, very new in India. It's not, seeped through, apart from the top tier corporate law firms. I don't think it's seen the light of the day when it comes to a predominant portion of the Indian bar. And I completely agree with Michael. I think it's a concept that needs some time to spread because India is a massive country. We have now just overtaken the United States and have the maximum number of lawyers in the world. But I actually had a question for Michael, and pardon me for sounding elementary. But today you enter into an arrangement with the client to finance the client for his pursuit towards a recovery. Now, of course, you will have an assessment of his entire case and, the red flags and the merits of his case. You will probably do an assessment. Is there a clause in that agreement that provides for you to interfere with the strategizing of that case as well? Or are you going to have a hands-off approach and let the lawyers do the strategy? Do you get to even, let's say, choose the lawyers of your choice? Do you get to intervene in strategy? How far? Because I think that is going to be a very important thing. Your lawyers are very territorial about the work they're doing, about the brief they have. And I can speak as a litigator as well. So pardon me if it's elementary, but if you just throw some light on it, it's a question on behalf of a lot of younger lawyers at the bar who would probably be wanting to know.
It's an excellent question, actually, and it's one that arises in a bunch of places where we work. And the answer is that, we conduct obviously an in-depth risk analysis, merits analysis of the case when it's brought to us. And that's not just, is it going to win or lose? That's everything associated with it. So we take a view of the client that we're working with. Are they reliable? Are they people we want to work with for the next 3, 5, 7, 10 years? Because it's these things are drawn out things. And are we working with lawyers in the case that we rate, we think are capable of achieving the outcome, and that we want to work with for that amount of time? And so if the answer to that is no, what we do is not replace the lawyers or take the case elsewhere, take it from them and install our own lawyers of preference. We simply turn it down. And there have been cases where we quite like the merits of the case, but for whatever reason, we lack confidence in the lawyers that brought it to us. So we say, no, thank you. And they're free to explore the market elsewhere. But it's very much part of our risk assessment. We're not in the business of replacing lawyers on cases. You can imagine how bad for business that would be if we did that. So we'd much rather say, no, thank you, than come in, interfere in the strategy, change the lawyers, and try and take a case in a different direction.
Thanks. That's very helpful. Thank you, Michael.
Yeah, of course.
Excuse me for taking down my backdrop there, but I see one of the attendees did ask, I assume it's directed to me, to remove the virtual background, the lovely, lovely picture of Hong Kong, because it was giving a distorted picture. And now you actually can see my office and the fact that it's nighttime here. And I'm having a lovely, lovely glass of red wine. So cheers. But on the same topic then, I was going to turn to the next question. What next for India, and what are you going to do? What's going to happen in terms of developments? What does India really need to do in order to get this issue sorted out? From a Hong Kong perspective, I'd say we need to get our legislation sorted out. We need to push forward, get these laws in place, get our restructuring laws sorted out, consider use trial laws. But what is actually going to happen in India? What's going to where are we going? Maybe Arush first. You can say a few words on that.
Well, as of now, what we insolvency lawyers are keenly watching is the Videocon Industries case. It's India's first group insolvency proceedings, which also provides for the insolvency of a couple of their foreign entities incorporated in the UAE, Brazil, and Indonesia that engage in oil and gas. Now, how are they going to utilize the proceeds of those assets? How are they going to be used in resolution? Are they going to engage with their country? Is a letter of request going to be issued? Because that case is still going on in the Indian courts. And as a person who's following that case quite closely and writing on it frequently, I would be keen to know, because I think this is going to be an examination of our cross-border regime. And as VP Sir said, do we have the appetite to go that extra mile to make sure that this group insolvency, which is about 13 corporate entities, out of which 3 are overseas, the court has recognized them as a single economic unit and has said that all creditors have a cross interest in the securities, and therefore they have a claim on the offshore assets as well. But how is it going to play out in reality? I think we'll wait and watch. And of course, apart from that, we're all looking forward to a sort of an umbrella model code which kind of ensures that there's unanimity amongst the major economies of the world with respect to their assets located in each other's countries, and for efficient enforcement. So I think those would be my closing 2 cents. Thank you, Wayne.
Vijayendra, what about you? What do you think? Where's it going? What's going to happen?
I see insolvency as a law which will be the next major fillip for M&A in this market. There is a lot of money that is available. There are good assets available. And if we get our game right, we can find assets and resolve assets not just in India, but also abroad. More importantly, we need to do this because we need to get a framework where we are known as a fair player, where we can invite people and are also invited by people to participate in the insolvency regime that is there. And I do believe that India needs to get that act right, because it'll only encourage a number of difficult situations to be resolved much faster and not just leave it to the good heart of the people involved or the good mind of the people involved. Because at times you may find neither in a difficult situation. And this is important because it actually helps India move from incredible India to credible India. Because you are turning around and making the same rules of the game that you want to follow yourself. And I do believe that the ILC report recommendation should see the light of the day soon.
I like that expression, incredible India to credible India. But I think India is both those things. I think it's an incredible place. I've been there a few times. I've thoroughly enjoyed my times there, I have to say. And I think it's very credible. Obviously, like many other places in the world, we all have to get better at a few areas. But we're heading the right way, I think, all of us. Michael, as we're closing, I think, because the timing is all a bit awry because of the other presentations going on a bit, I just wondered whether you had any closing comments you wanted to make with regard to your business and India and what you hope will come of it.
Just to say, continue to bear with us as we get to know one another, I suppose. Like I say, there will be an example that people can look to as something that worked soon. And I think once there is an example, then things will open up, the market will open up for this, and people become much more, I suppose, familiar and comfortable with it. So it's just going to take some time. So I would encourage patience more than anything else.
Again, very wise words. Nothing wrong with being patient. As we sign off, I'd like to thank everyone involved in this particular summit that's been going on for some time, I see, and also all those sponsors who have been involved. And of course, you guys, the panelists, for contributing, which has been very helpful and very useful and very informative, I think, certainly for me, that isn't entirely au fait with the system in India. And when I have been involved with it, it hasn't necessarily been so good from my perspective, generally speaking. But I certainly value and appreciate the optimism of the future. And I think that's a good thing. But as I sign off, of course, I'd like to make a pitch for my home city here of Hong Kong. And I hope when you're all able to travel again, that you will visit here. It's a very special city. It's part of China, of course, but it's a city on its own, makes its own policies, its own rules, has its own police force and borders and its own laws and its controls and so forth. And this, this city, like India, is in another country with a billion people over there in what is shortly to become the world's largest economy. So it did definitely the place that you want to be doing business with in Asia. And there are quite a few pros to that, of course. There are the taxation simple and low, no GST, no VAT, no inheritance tax, no tax on dividends. We have a well-established professional network, of course. The world's top IPO fundraiser, which we remain to be, and we have a stable currency. But most of all, we have more Rolls Royces per capita than any other country in the world. We have more skyscrapers than anywhere else in the world. Yet 40% of Hong Kong is country park. Did you know that? We have the longest suspension bridge. We have the longest escalator. We have the fastest internet. We have the most efficient subway in the world, 99.9% on-time rate. And we have Disneyland. So what can I say? Gentlemen, thank you for joining the panel. I don't know whether I think according to my timing, we're on schedule, but I'm not quite sure what happens now. But it was a pleasure, certainly from my perspective, to meet the two of you again. Michael, I met before, but it's nice to see you again as well. And thank you very much.
Thank you, Ian.
Thanks, Michael.
Thanks.
Have a nice Friday evening. Thank you.
Oh, I will, and you. Cheers, gentlemen, and for all the people watching, good health, and Look after yourself.
That's my
Stay
coffee
safe.
to you.
Stay safe.
Thank you.